First of all, I have to thank my right honourable friend, the member for Horsham, for securing this debate and continuing with the conversation that we've had for some time. I was pleased to meet with him and his constituent, Mr Turner, last May to discuss this issue, and I do welcome the ongoing debate we're having. Ms Ellis, I won't tiptoe down memory lane like colleagues have. I'm not sure what value revisiting the coalition government of 2010 onwards is particularly helpful to today's debate. What I do want to do, I think it's important, and I'm sorry if it's going to be dry, is it is important to actually lay out the legal framework that is there to protect vulnerable people. And I understand very clearly the actions of the vast majority of parents are well-intentioned and act with great honour and kindness looking after their child or their young adult. However, my job, of course, is also to protect vulnerable people from any form of abuse. And that weighs very heavily on any reforms that we take forward. And I appreciate people will disagree vehemently with me, but I do have to take into account that not every parent would act with the best of intentions when accessing these funds. We do know, Ms Elliott, that it's a well-established common law principle that an adult must attain proper legal authority to access or manage the finances or property of another adult. That includes, for the purpose of today's debate, a matured child trust fund of a young adult. And people are understandably unaware of this legal principle, and it may be surprising to parents and carers who've been very heavily involved in the decision-making for their young person prior to them turning 18. And I do want to iterate what steps we've already taken to try and improve the process, and also particularly to try and improve the awareness of what steps need to be taken as the young person goes over the age of 18. Of course.
I'm grateful for Mr. Dinway. Before he talks about the reforms that have been made, can I bring him back to the point of principle he just outlined at the beginning of his remarks? I don't think anyone disagrees that there's an important principle there, but there's equally a principle of proportionality, which I made in my speech. Could he address that point? Where does proportionality arise in his thinking about principles involved?
Well, I have to say to the right honourable event, I'm very happy to have an ongoing conversation. In fact, this is the first time we've actually discussed this face-to-face. We've not discussed this before since I took on this portfolio. But proportionality is a very valid point. But what is the level of risk the right honourable gentleman is willing to take will be very different from the level of risk I'm prepared to take or the government is prepared to take. The right honourable gentleman, anybody in this room, may be prepared to say 10, 20, 100, 1,000 young people could have their money accessed inappropriately. That's the proportionate risk they're willing to take. My view is I want to minimise that risk, and their proportionality is not an easily measured. I'm not a lawyer, there may be a legal, and I look to my right honourable friend who I think is a lawyer. I look to my legal friend and say maybe there is a definition of proportionality, but the definition of proportionality on those who are making decisions against those who are asking for change may be very different. Now, I'm willing to see if we can bridge the gap, but my view is I want to ensure that we can improve access, but also ensure that protections remain in place so that those who may not have the best interests of the young adults in mind do not get access to the funds with total liberty.
I'm grateful for the Minister's answer. It was direct to the point, and he's given way again, which is very generous. When we're looking at this risk, though, we actually have evidence from the industry. The industry's looked at this case, and many of the firms and funders have said, we're prepared to take the risk on ourselves, even though the government is behind it. These firms, because the risk and the amount of money is so small, they've taken that risk on themselves. Isn't that not a lesson that the minister should dwell on? And if the MOJ isn't prepared to act on that, would he at least go and talk to his colleagues at the Treasury and see if they can make a statement about the way that the financial services could take on that risk and how the government would support that?
Certainly, I'm always happy to discuss with any provider, and certainly the provider I've spoken to and no provider has beaten their path to my door saying that we think you've got it wrong and our risk assessment is right. Of course, any organisation is entitled to make their own risk assessment and take the consequences if they get it wrong. And that's there for their decision. My risk assessment is perhaps I'm being overcautious. I'm willing to be challenged on that, and I appreciate people have a different view. But I want to ensure that I take the least risk to vulnerable adults. But certainly my conversations, I will talk briefly in the time left, about the work we've done with TISA to try and improve accessibility and knowledge. So if I may, Ms Ellis, I'll have to skip over now, given the time, about the legal framework of the Mental Capacity Act. I think everyone in the room is probably aware of the methodology of applying for the deputyship that gives people access or the ability to act on other people's behalf. So I won't go through that in any great depth. But we have heard that the court process was cumbersome, and that's why we did look to see how we can change that. We did consult as to what kind of different system we could put in place, but there actually was not a consistent view from the consultation on how we should reform the access to these funds. Because in fact, when you go into the consultation, many people wanted to add safeguards into a new form of access that actually made the system even more cumbersome than the one we were trying to reform. So that was a difficulty. We didn't get actually a common view on what checks and balances needed to be in place. But we also did just talk to parents, we talked to charitable organisations, legal and finance sectors, groups representing the elderly, etc., etc. And what we did here is it was too complex, but the big message that came out was that people weren't really aware of what they had to do or when they had to do it. And so one of the things I think that my roundtable friend asked, I think it was his first ask, was would we extend appointeeships to cover child trust funds? We are working with the Department for Work and Pensions to extend the availability of information. And so without taking out at all, I'm more than willing to go back to the DWP and talk about whether their process is suitable for child trust funds. It's a very different process in terms of it is accessing regular payments rather than lump sums. So there is a different quantum at risk, but equally it would take primary legislation. So it is not, we double-check this today, it would take primary legislation to, if you like, copy or access the DWP-type processes. So it's not a quick fix, but it's certainly one that I'm more than happy to go back and have another look at. But in terms of what we've actually done, is I wanted to ensure that we've been trying to streamline the process. Can we take the paper out? Can we use more digital processes? And what we've seen is that the time has been reduced from 24 weeks to 12 weeks currently. And we'll continue to liaise with the President of the Court of Protection to monitor performance to see what more can be done. Now, one of the key issues is that people often don't know what they have to do until the child turns 18, and then they are locked out. So what we are looking to do, and we've done first two things, and apologise if this sounds a little disjointed, but I sat down with TISA, the major provider of these child trust funds, and we have agreed that they will write out, as part of their normal maturity mailing, they will include in that mailing advice and information about how to actually access and use the Court of Protection to get the relevant legal powers in place. So that we are taking early steps to educate people as to what they need to do before the person turns 18. That alongside, as honourable members have commented, the toolkit, which provides practical guidance in terms of how to access the legal process and how to navigate through it. I've mentioned also, the mailing that we've agreed with TISA, but also one of the second asks was making people aware of how to find these lost funds. And so we are doing more work to provide information, and people can use the Find My Child Trust Fund service on gov.uk, and we can continue to do more to raise awareness of that, so that people are, of course.
it's good that the Minister for giving way. I'm just listening. I think it's a good idea that the providers are prepared to write out and provide additional information, and I personally welcome that. It's not going to solve the problem, but what I would say to the Minister is, does he agree with me that it's no good that just being a one-off? This is going to have to be something that's done on a regular basis, because as young people become more and more mature and move towards the age of 18.
The honourable friend, the Shadow Minister, preempts. This is a regular communication strategy. TISA will continue to notify those who are heading towards maturity what they need to do to actually access once they turn 18. Alongside that, I've been working with the Department for Work and Pensions on accessing their client bank, and so we have agreed that they to be able to contact with DWP the cohort of parents and carers who receive PIP payments who may lack mental capacity to access their child trust fund. And we have an agreement in principle that we were doing a mailing, and this will not just be a one-off, this will be a constant mailing, so that as people in those cohorts, which we think is particularly relevant to the child trust fund and difficulties of access, became aware in advance of what they need to do. Because one of the big messages from the consultation was our lack of understanding and our lack of knowledge of the steps until it was too late. So I appreciate that members have said, give them the money. But equally, and I get that, and as I've mentioned at the very start, for the vast majority of parents, they act in the very best interest. And I'm not a parent, so I cannot possibly understand the role of a parent having to juggle all of the demands of everyday life and having a child that needs additional support. And I accept that my knowledge is very limited, but it does weigh very heavily on me that I want to ensure that just one parent not acting in the best interest and accessing those funds inappropriately weighs very heavily on me. So I accept all the points of proportionality, and I'm very happy to have a conversation as to where that line is drawn on risk. But broadly speaking, where I'm coming from is improving education, improving access, improving knowledge. But I'm not going to, and I cannot in all conscience say I'm going to throw open the accounts and give unfettered access without some checks and safeguards to ensure that a very small minority do not have the ability to abuse a young adult. But I will commit to following through with colleagues at DWP on the scheme they use to see if there's anything we can do to copy it or piggyback it to make the system more accessible. Thank you, Ms. Hyde.
Sir Jeremy Quint.